Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on intellectual property. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. So, when it comes to employment or employees, your employment relationship with your employer is, of course, regulated by your employment agreement. Your employment agreement is likely, to set out the number of hours you work in a week, the number of days you're entitled to leave, your remuneration, and anything and everything that relates to your employment. Now, when it comes to IP, in some instances, some employment agreements, regulate intellectual property, and in some instances, employment agreements don't regulate intellectual property. I think it is, of course, important if you are an employee, you actually have a look at your employment agreement to see what it says about intellectual property. I have seen employment agreements which I've reviewed, which provide or set out that if an employee during the scope and course of their employment, in other words, during their working hours, creates intellectual property, either a concept, idea, a methodology, using the equipment, in other words, or the tools that belong to their employer, that intellectual property, although it's created by the employee, is regarded or will be deemed to be intellectual property belonging to the employer. So, in other words, you can actually create a concept, but because of the terms and conditions of your employment agreement, that concept might not belong to you. It might belong to your employer, provided, of course, that it is a concept or a methodology or an idea that you create during the course and scope of your employment, in other words, during your working hours, and you are using the tools or equipment that belong to your employer. Now, this is, of course, not with all employees, and how you'd establish what your intellectual property belongs or doesn't belong to you. You'd have to rely on your employment agreement with your employer. Now, I mentioned the case with Vodacom and Mr. Makete. Mr. Makete, of course, came up with this brilliant idea called the Please Call Me sometime in the year 2000, or I think 2001. Vodacom has generated an extensive amount of money, and unfortunately, Mr. Makete and Vodacom haven't come to an agreement when it comes to how much Mr. Makete should be paid by Vodacom. What we do know about the case, it's gone through a number of courts in South Africa. At some point in time, it was in the Constitutional Court, and the Constitutional Court for one criticized Vodacom in saying that some of the executives or former executives of Vodacom who brought evidence or were testifying for and on behalf of Vodacom were very dishonest to the court. There were also allegations by Vodacom at some point in time that Vodacom alleged that the Please Call Me concept didn't belong to Mr. Makete, but that he had rather stolen it from MTN. There was also a Vodacom executive who actually wrote a book and claimed that the Please Call Me concept belonged to him. This is despite that the media articles that were out, and that there was communication from Vodacom wherein Vodacom had commended or congratulated Mr. Makete for this very brilliant idea. So I think what is difficult about this with Mr. Makete is that Vodacom has tried to maneuver around this matter for quite a long period of time, but because Mr. Makete entered into a verbal agreement with Vodacom, it was actually difficult to prove that there was an agreement between him and Vodacom that he would be remunerated. So if you are an employee, I think this is an important lesson that you can learn. Always try and protect your intellectual property. If you can, of course, you can register the intellectual property. That's how you protect it. In an instance where you are unable to protect intellectual property, in other words, go through the process where you register the intellectual property. At the very least, before you pitch an idea or a concept to your employer, have an agreement with your employer and say, I would like to pitch an idea, but before I pitch that particular idea, can we enter into a contract? And the terms and conditions of the contract would be what you prefer. But you could, for instance, incorporate things like to say, if the company that you work for chooses to develop the product and so forth, you will be remunerated for a certain amount. As an example, you can decide what that amount would be, but it is actually important that, I think, before you even pitch the concept, don't enter into the contract after you've pitched the concept to your employer. Enter into a contract before you've pitched to your employer. So then the question arises, if you have an idea or a concept and you'd like to pitch it to your employer, is it better suited to pitch it after you've registered it, or before you registered it. So the process of registration of intellectual property, either a copyright, a patent, a design, or a trademark, is of course done through the CIPC. Once you have registered intellectual property, you have the option as the owner, of course, of that intellectual property, either to license the intellectual property, you can franchise intellectual property, you can also assign the intellectual property. So when you assign intellectual property, you sell your intellectual property to another person. When you license your intellectual property, you give rights depending on the terms and conditions that you entered into to another person for a certain period of time, and of course that person will remunerate or compensate you. So there is a benefit to registering intellectual property. You can commercialize it, so you can take the particular product, you can develop it, or somebody else can develop it on your behalf, and then they can actually pay you for intellectual property. Versus an instance where when you don't register intellectual property, you might find yourself in a bit of a difficult position. I definitely think that it is better suited in an instance where you can't register intellectual property to actually enter into an agreement with your employer to say, okay, I might not necessarily have the means to register this intellectual property, but I would like an agreement that is signed prior to me pitching the concept, and should you then develop the concept into a product, you will then remunerate me a certain a certain amount of money, or I will be given, I don't know, shares or whatever you would prefer to be given, even if it need not necessarily be money. In some instances, I know people request non-disclosure agreements. You get a non-disclosure agreement, you pitch a concept, and thereafter you enter into a contract should your employer decide to develop the product further. I don't prefer non-disclosure agreements. Non-disclosure agreements, specifically for someone who might not have the resources to enforce a non-disclosure agreement in court, may be problematic. So you might have entered into a non-disclosure agreement, but if you can't enforce the non-disclosure agreement, what good or benefit does that non-disclosure agreement have? So non-disclosure agreements are a valid and binding contracts, of course, and a non-disclosure has the intention of saying, if you sign a non-disclosure, whoever you disclose the information is prohibited according to that non-disclosure from disclosing that information to another person. So for instance, if you're an employee, you pitch a concept to your manager, your manager is then precluded from disclosing whatever that concept is to another person. So non-disclosure agreements are great, but I have an issue with the enforcement of non-disclosure. And my preference when it comes to intellectual property is always to register intellectual property. And in the event that someone actually tries to steal your intellectual property, once you have registered it, you can preclude them or prevent them from doing so. But realistically speaking, I do understand that not everyone has the resources, in other words, the money to get your intellectual property registered. It's not something that also comes very cheaply. But I think from our conversation today, what we can learn specifically from the case of Mr. Makete with Vodacom is that as an employee, you shouldn't actually always assume that your employer has your best interest at heart. Specifically, that because you may have pitched a concept or an idea to your employer, you are guaranteed to be paid. Always ensure that you enter into a written agreement, which I think is preferable, but you can enter into a verbal agreement. In the case of Mr. Makete did enter into a verbal agreement, and it has proven to be very challenging. It's not to say that verbal agreements aren't valid and binding. They are definitely valid and binding, but the enforcement of verbal agreements is very difficult. So I think that when it comes to pitching concepts, always try to pitch the concept, always rather enter into a contract prior to pitching the concept to protect yourself. Try to avoid also entering into verbal agreements. Verbal agreements usually end with a I said, he said, she said, they said. So it's not to say verbal agreements are not binding. They are valid for one, and they are also binding. But I think it is better suited to have a written agreement in place with your employer if you have the intention to pitch a concept. And of course, as an alternative, you can always register the intellectual property first. I do know, of course, that not everyone might have the money to register their intellectual property, but in the event that your employer doesn't take interest in the particular intellectual property that you create or develop, you can always sell or market that particular product to another person. Thank you again for watching, and I hope you enjoyed our episode today.